Welcome, everybody, to the case summary updates for the month of June 2026. This is being sponsored by Veritas Workplace Investigations. And today, George, Bean, and I are going to discuss the cases that we found interesting that were published by the Court of Appeals in the last month. And to lead that discussion, we're going to begin with George. George, I suggest that you discuss the case of, and I'm going to kill the pronunciation here, Decloedt.
I think there might be a lot of extra letters. I'm just going to say Decloedt. So we've got Decloedt versus RadNet Management. This is a case that involved sexual orientation harassment. And the defendant filed a motion to compel arbitration, and the plaintiff defended against that and invoked the EFAA, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. And the defendant said, well, wait a minute, this is about sexual gratification harassment. This is not about sexual orientation harassment. You can't invoke the EFAA for something that it wasn't intended. However, this Court of Appeals said, nope, the EFAA does apply to sexual orientation harassment. Coincidentally, I had this exact same argument in this exact same format. I was on the plaintiff's side, filed a complaint for sexual orientation harassment. The defendant filed a motion to compel. I ordered that. I argued that the EFAA applies, and the court agreed with me. This was the Superior Court in Los Angeles. And my argument was based more on federal law, even though this case discusses PAGA a decent amount. Under federal law, the original prohibition against harassment didn't really define the word sex very well. They just said that, you can't harass on the basis of sex. But subsequent jurisprudence defined sex as to include sexual orientation harassment. And the Superior Court agreed with me up in Los Angeles about a year or two ago. And now we have a Court of Appeal decision saying that, yes, indeed, the EFAA now applies to sexual orientation harassment. Comments, Javier?
So, George, I understand that you see this pretty clearly. Do you think this is going to make it to the Supreme Court?
I would love it if it did.
Now, to take a step back, my understanding is that there was an arbitration agreement that required the employee to see their case in arbitration. But the plaintiff's attorneys alleged that because there is a federal law that prohibits mandatory arbitration in cases of sexual harassment, the case that was based on sexual orientation could not be forced to go to arbitration. And that's a point that you won. That's the point in this case. The plaintiff won, and the Court of Appeals, this Court of Appeals said that that was a correct reading of the law. So I understand that. But on the other side, the law is part of the law is technicalities. So if we look at the definition of the federal law that required for people who had a sexual harassment case, who had a sexual assault case, and if we consider that that law was part of the Me Too movement, when a famous Hollywood producer was forcing people to have sex in order to get parts in movies, that's the yucky, ugly part that should not go to private arbitration to be kept secret. If that is the purpose of the law, then it is inconsistent just to have a mere harassment case based on sexual orientation be out in the open if the parties agreed to an arbitration agreement. Because after all, the United States Supreme Court has said many, many times that they favor arbitration. So which is it? Do we favor arbitration, but not for the ugly cases? Or do we favor arbitration for all harassment cases? And that's a concern. Is this a slippery slope? What do you think?
Understood. The slippery slope argument is alive and well here. I think this court just leaned on the definition of sex in the federal sense, like at least in my case, that's what I believe the court leaned on. And they've decided this is the way they're going to go. As I've said in so many cases, it depends on the judge you get. And we know the makeup of the California Supreme Court, and I have a feeling I know which way that decision would go.
You're in good company with the Court of Appeals law. So, George, changing the subject radically, now I would like to talk about the case of the people of the state of California against the Federal Motor Carrier Safety Administration. And this is a 2026 case in which the Ninth Circuit Court of Appeals, this is a federal court, decided that the rules that were implemented by the agency that is in charge of regulating public transportation, those rules were valid, and those rules displaced, by preemption, California law. Specifically, meal breaks, rest breaks. So the argument was that the taking of meal periods, the taking of rest periods was, according to the court, imposing a significant burden on employers, that those breaks were disruptive to schedules, increased costs, reduced operational flexibility, and made compliance difficult. Well, yes, it is true that the California rules concerning breaks is so hard to comply with that it is disruptive to all employers. So the question is, why would, in this case, made a difference? And the answer came from the United States government, who in 2020 ruled that because was disruptive to transportation, California could not regulate that, and the transportation employers just needed to comply with federal law and disregard California law. There was a case in 2021 from this court that said that that was the rule for good carrying transportation services, truck drivers driving stuff. And this case in 2026 extends that ruling and that rule to people carrying vehicles in the interstate commerce. Although this applies on point to a small industry and not everybody deals with these types of cases, I think this is an important case to know, because the argument is that California law that is disruptive may be against the will of Congress if the employer is in the interstate commerce. What does that mean? Does that mean that in the future, there's going to be other employers challenging other California laws based on preemption? I don't know, but it seems to me that there's an argument to be made. What do you think, George?
Yeah, this is a weird intersection of interstate commerce and intrastate commerce. California has more robust wage and hour laws than most places, if not every place. Yet at the same time, truckers need to move across state lines, and then do the rules change every time you cross a state line? Sort of a fun story about this is my older brother was in the Army, and he, after he got out, he owned a gun, and he was a repair person for a copier company, and he traveled in the eastern part of the United States, where the states are smaller, and he crossed state lines a lot. So he told me when he crossed one state line, he'd move his gun from the glove box to the seat. When he crossed another state line, he'd moved it from the seat to the trunk. When he crossed another state line, he could put it on his lap. And so it really makes for a difficult situation for transportation when the truckers have to abide by 50 different state laws. So I understand the preemption. From the plaintiff side, would I like to see more flexibility and more ability for plaintiffs to win their cases when an employer forces a trucker to stay awake for too long? Sure, I'd love to see that. But on the other hand, I do understand the manageability issue of preemption and crossing state lines.
Although it is understandable, this may be another slippery slope to take away rights that California employees have had for a long time. Do you see that risk?
I do. We have federal preemption, and truckers cross state lines. So I'm not sure it's as slippery a slope as others.
So, George, let me ask you this way. What is the takeaway from this case for people in the employment sector?
That don't do cases in the trucking industry. They're way too confusing.
I think that the takeaway is, like, be mindful that federal law may apply, and in some cases, do away with the Californian strict requirements. Maybe.
Oh, sure. That's the real takeaway.
Yeah. On that note, and I'm laughing and I chuckle because it's like, wouldn't it be wonderful for most defense counsels to be able to kick out California rules? That's a wish. That's a wish, but it's not going to happen. That's why I laugh. But changing the subject to a different case, that takes us to the Quinteros v. Harbor Distribution. I cannot say it, Distribution LLC. George, what happened in that case?
This is probably a topic everyone's become familiar with, but we're going to emphasize it one more time. The attorneys in this case on the plaintiff side filed a brief that about half of the citations to law either didn't exist or were the opposite of what the case stood for. It seems pretty obvious to the court and to opposing counsel that the plaintiff side had used AI to draft their brief and did not check the citations. Now, interestingly, this is a law firm that both Javier and I have opposed, Javier multiple times, myself at least once. We're not overly surprised by this. They are local. We won't say their name on this broadcast, but I do want to quickly read just some of the fun stuff that the court said. The law firm repeatedly cited and relied on two cases as authority, but as the court noted in bold font, quote, neither citation is accurate or even exists. They went on and on, but they ended up sanctioning this law firm $5,000 payable to the defendants and $1,000 payable to the court. Just another reminder, AI is wonderful, but use it correctly. Check your citation, people, please. Javier?
George, did the court impose a duty? Did the court say that attorneys have to do something?
Did they, what do you mean? Like, did they have to like put a cover page on all future briefs or something like that?
Something like that, or did the court say that attorneys must now, represent that they didn't use AI, or if they did, they have to then make a statement that they checked the sites? Did the court say anything like that?
I did not see any of that. I think the primary punishment was the sanction.
And the reason why I ask is because I have seen other courts in AI cases, and I'm trying to pay attention because AI has allegedly been, the allegation is that AI is already practicing law, right? So I'm trying to pay attention to see what's going on. And some courts have come down really, really hard on attorneys. So it seems to me that in this case, this law firm, which again is local and shall remain nameless, got away easy. Do you think?
I don't know. Everybody knows now. I'm the opposing counsel. I'm not the judge, but yeah, I do
see what
enjoy
you're
those.
saying, that the reputational harm is harder than and harsher than the financial penalties.
I do enjoy those cases where the judge forces that firm to put a cover letter on everything they file for the next 5 years, admitting to what they did. That's kind of fun.
But to be fair, that's not what happened in this case.
No.
So what is the takeaway?
Takeaway, check your citations when you use AI. It's possible we may even get to a point where you're committing malpractice if you don't use AI. So this is not a topic you can avoid. This is a topic you need to understand. This is a topic that you need to explore. You need to understand if even at some point using AI destroys attorney-client privilege. In your account that you use. For example, we use a ChatGPT account that's a private account. It doesn't train its model. We have a personal account that doesn't upload any of our information to the internet. When I use something on the internet, such as Gemini, I have it set to delete immediately. It deletes immediately. When I use Claude, same thing. I have these proprietary accounts where my information is just not available to a third party, and so I'm avoiding the loss of privilege. But the main takeaway from this case is check your citation, people, please.
And also, I think another takeaway is that there are non-AI tools to check citations. Make sure that you're giving the court a case that actually exists.
And Lexis has one. It's called Create, Lexis Create. I've used it in the past, and it's still very buggy. So I'm still going in. I'm still reading cases before I cite them.
I hear you. Now, changing the subject to a different case, this is the Askins v. CRST Expedited Inc., which I'm going to discuss. And what happened in that case was that the plaintiff filed a lawsuit alleging that the employer performed a background check using documents that were not in compliance with the laws that regulate background checks. That because the forms were not 100% what the law required, this person suffered damages, and of course, being California, it was brought as a class action. The trial court certified the class, but then while the class was being certified, or after the class was certified, another court of appeal ruled that those requirements did not apply if the plaintiff did not suffer harm. Let me say it again. Unless the plaintiffs suffered a harm, the plaintiff could not bring a class action, said the court, reversing and then leaving the case without a class. Plaintiffs appealed, and in this case, the Court of Appeal ruled that under the California pleading rules, you do not have to allege that the plaintiff suffered harm in order to have a class action. It was reversed, and this is going now to be a class action. Interesting, because it seems common sense that in order for you to bring a claim, you have to have suffered some type of harm, not just a technical violation. But the Court of Appeal in here is saying that in California, under the California pleading rules, who cares if you suffer harm? Of course, you can have a class action. Bring it, and let's sort it out. Too ironic? Too ironic?
Not really. I think I see the court's point. One, if legally it's not required, that's one ground to stand on. Another is that these various regulations are in place for a reason, and the very fact of the violation implies injury. If somebody runs a background check on you and doesn't do it correctly, I mean, that sort of implies injury. The Congress or the legislature wants procedural protections in place because it protects the person being investigated. We're in an era where a lot of our personal information is probably available on the internet anyways, but I think there's a reason legislation was written, because it harms somebody.
And let me push back a little, George, because I think I heard you say that a person may suffer a harm, but in this case, there was no harm alleged. It was just that the forms were faulty. Nowhere was it alleged that the background check was faulty, bad, gave wrong information. It's just that the forms were not using the magic words, and that by itself, a technical violation, leads to damages on a class-wide basis against the employer. Some people may argue that this is another California way of driving employment to other states. And some people may argue that this is California protecting people because California is for the people. I don't know. I'm just asking questions.
Understood. I was making a general point that, violating even technical aspects of a law, the reason the law exists is to protect people.
The takeaway here is, I think, make sure that you use the right forms, particularly when, in order to have a cause of action under these laws, you need to hire a third party. So if you're going to pay somebody to do it anyway, make sure as an employer that you hire the person using the forms with the magic words. What do you think is the takeaway, George?
I think that's that. You got it. Cross your T's and dot your I's.
Which leads us to, this is going to lead us to a case that I think we should mention because it's important, although it is on the subject of PAGA, the Private Attorney General Act, which in California has become a game, my opinion. I think we should mention it because it seems to me that every employment practitioner deals with PAGA at some point. And this is the case of Tanduran v. James Gladwell. This is a case where the trial court, reduced the amount of penalties under PAGA because the court felt that the penalties were unfair, unnecessary, and they were just too high. This is my paraphrasing, right, of what the court did. The plaintiffs, of course, went to the Court of Appeals, and the Court of Appeals said that the trial courts have ample discretion in evaluating the amount of the penalties and establishing an amount of penalties that the trial court feels is appropriate for the violation. Now, why is this important? Because the Court of Appeals said that the law, PAGA, does not have a formula and does not have a specific way for the courts to impose penalties, either to give penalties or to reduce penalties. And because there is no guidance from the law, it is the discretion of the trial judge. In this case, the penalties were reduced from $55.9 million to a little bit over $500,000. So it was not a reduction. I think it was a gutting of the damages. And the Court of Appeal didn't have a problem with the trial court doing that. George, what do you think of this case?
It's interesting. I have seen a lot of judicial hostility toward PAGA. And I think this is maybe an example of that you said it's become a game. And I think the courts are picking up on the fact that some people take advantage of the law. It's something to hold over the employer's head. Now, don't get me wrong, as a plaintiff's attorney, I do believe that employers have probably committed a lot of the violations that have been alleged against them. But at the same time, this is a blunt instrument that could basically put companies out of business and has put companies. I've had a case where, and I was on the plaintiff side, and looking back, I wonder what I would have done differently. The defendant ended up disappearing. And part of the problem wasn't that I got an outlandish sized settlement or judgment against the defendant. It was that when we came to a reasonable settlement agreement under six figures, the court rejected our settlement. And so I've seen a lot of hostility towards PAGA settlements that make the cases virtually unmanageable from the plaintiff and from the defense side. And so, sure, it's become a labyrinth. It's hard to manage. And the court's hostility towards it discourages plaintiffs' attorneys, at least people like me, from bringing those types of cases.
I hear you. I hear you. And to be fair to the process, if there is a violation, there should be a penalty, but the penalties should not be oppressive, which was the finding of the court here, that technicalities and looking at the numbers and crunching the numbers, just following the basic rule on penalties is going to be millions and millions and millions of dollars when the whole enterprise is not worth millions and millions of dollars. Of course, if you have an enterprise that is a $1 trillion company, well, they can probably pay $55 million. But for a normal employer, this court found that that will be oppressive, and the reduction, according to this court, it was enough. I think this case is going to go back up to the Court of Appeals, but we'll see. We'll try to pay attention. So the takeaway here is it seems that the courts are finally grappling with what the actual damages in PAGA look like. And this may be good for employers, it may be bad for employers, it may be good for plaintiffs, it may be bad for plaintiffs. What do you think, George?
I'm just glad I don't own a business in California other than my little solo practice here. You made a comment that that businesses are being driven out of California. Maybe, there's brick and mortars and you can't really buy coffee from Arizona if you want it hot. So yeah, maybe some businesses are being driven out of California. And I think PAGA is just clunky. It's such a blunt instrument. Do we want to hold employers accountable? Of course we want to hold them accountable. Is this the right way to do it? I don't know. It feels like almost every PAGA case and even some class action cases are very much gamesmanship. And people see, each class member gets $32.14 and the lawyers get $2 million. So I know I'm from the plaintiff side, but it's not that I can't see these things.
I hear you. So with that, these were the cases that we thought were necessary to discuss that were resolved during the main month of June 2026. We're going to do this again next month and bring the cases of July. Should be short. It's a summer break. So with that, enjoy your summer, and thank you again to Veritas Workplace Investigations. Thank you.